Okay, welcome to Inside the Criminal Law. This is going to be Chapter 3. We're going to be looking at the federal and state criminal laws, and we're going to look at some highlights, some of the unique features that are not in your text that have to do with North Carolina and the criminal law. So there's a few permutations there, a few changes, but I think they're pretty self-explanatory. Okay, so again, these are your learning objectives. You can read these over and you'll get a pretty good idea of what we're attempting to cover by and large in this chapter, but you don't have to specifically know each one of these to really learn and understand what we're doing. Okay, so let's talk about where the law comes from, the sources of the law. Now, first of all, you have law can be broken into any number of different categories. Sometimes you hear the term civil law, criminal law, you hear tort, you hear negligence, you hear strict liability, you hear all these different terms. But let's talk about how categories can arise in regards to sources of criminal law. So, first of all, we have to have the Constitution. Now, the Constitution is kind of unique here, both the federal and the state Constitution, in that when we say it's a source of the criminal law, it's more a constraint on it. So if you looked at the federal Constitution, the Constitution that everybody is probably most familiar with, there's not a lot of actual criminal law in it. They certainly don't do things like define what murder is or talk about burglary or robbery or rape. So the federal Constitution is, strictly speaking, not a way in which you can figure out what the law is. It is, however, like I was saying, a constraint upon the criminal law. There are certain things that, because of the structure of the federal Constitution, you can't do in the criminal law, or you have to do in the criminal law. The state constitutions are like this, but even more so. We have to remember, though, that the federal constitution, if it conflicts with the state constitutions, the federal constitution is going to win. It is the supreme law of the land. As interpreted by the highest court, which would be the Supreme Court of the United States, the federal constitution is the highest court. Now, of course, every state, including North Carolina, has a state constitution. The bulk of the actual criminal law that you're going to see, so defining things like what's a homicide, or what's burglary, what's rape, all of those are pretty much statutory laws, either passed by Congress, or if we're using the example of North Carolina, since most of you, of course, are North Carolina citizens, and you're taking this class in North Carolina, they're going to be passed by the general legislature, is what we call it. Now, they don't have to be passed recently. Some laws are very old. We've always had a statute against homicide since the birth of the American Republic, since the 1770s. So the federal law is law that's passed by Congress. It has an impact on the criminal law in defining things, but not as much as I would say the state law. So in North Carolina, the vast bulk of the law, if someone's going to be arrested for a crime, it's going to refer to what general statute, or sometimes you'll see the term NCGS, North Carolina General Statute, what law was passed to make this illegal. Okay, so North Carolina's actual criminal law passed by the legislature is going to be found in Chapter 14 of the North Carolina General Statutes. So what's a chapter in okay. They took all the laws that have ever been passed that are still in effect in North Carolina, and they broke them up into groups, and they call these groups chapters. If a new law is passed, so let's suppose we make it a crime to shingle your roof on a Sunday, we would add that to Chapter 14 of the North Carolina General Statutes, and we're up to about Section 461. So let's suppose that law would become 14 NCGS 462. 14 refers to your title. North Carolina General Statutes where you find it, and the final number there is the actual statute. So if you are looking through this, and there is a link there for you to take a look at about North Carolina general statutes, if you look at the statute, what you'll notice is most of what people are very familiar with, the very significant crimes, again, murder, um, rape, assault with a deadly weapon, those are all found relatively early in that, so at the beginning. It's only later that you have some of the more rare or revised statutes. Now, that's not to say that all the criminal law is going to be in Chapter 14, because we are going to find some of the motor vehicle law, and there's some criminal law in the motor vehicle law, up in Chapter 20. Because when they were breaking it up, they said, okay, 14 will be for the criminal law, 20 will be for motor vehicles, and some of that is not criminal, some of it's like how do you register a car and your taxes and stuff. But there are a few parts of Chapter 20 in North Carolina that are things like speeding. So there are some criminal statutes there. Okay, let's talk a little bit about that federal constitution. The federal constitution, the one that's in effect today, a couple interesting things about it. First of all, it is the oldest functioning constitution on the planet. Now, there are unwritten constitutions such as England that are older, and there are older semi-functioning democracies, but no written constitution predates ours that is still in effect. So our written constitution was drafted in Philadelphia in 1787. It was primarily to set up the federal government. It was revising the old constitution that came before it called the Articles of Confederation. But there were a few mentions in this constitution of 1787, adopted 1789, about criminal rights. In particular, the first 10 amendments to the Constitution, which were seen as restrictions, at least initially, on just the federal government, had reference to criminal law. Now, the state constitution, North Carolina state's constitution, the one that we're currently living under, dates primarily to 1868. Now, there was a revision in 1971. There's been a few subsequent revisions. And of course, we had a constitution before this. We had a constitution from the 1770s. One of the conditions for the readmission of North Carolina to the Union following the Civil War was they had to adopt a new constitution. This new constitution did things like prohibit slavery. I believe it also had to repudiate the war debts of the Confederacy, a few other things. The major difference, if you were to look at the North Carolina state constitution as opposed to the federal constitution, is in the federal constitution the Bill of Rights is at the end. In the North Carolina state constitution, because it's written almost 100 years after, revised 200 years after, they put all your fundamental rights at the beginning. They put them in Article 1. So it's kind of reverse what you see. Now, there are some criminal laws that are talked about in the North Carolina state constitution, but again, most of that is left towards the statutes that have been passed in North Carolina. Okay, another source of law that most people don't appreciate or understand is what we broadly call administrative law. So what's administrative law? Administrative law are rules and orders and decisions of federal or state governmental administrative agencies. So here's the way to think about this. The Internal Revenue Service federally, or the North Carolina Department of Revenue, that's the state analogous administrative, they can set up certain rules. They can say, okay, you have to pay your taxes by April 15th. Or they can say, if you fail to pay your taxes, we can subpoena your bank records. So it can say, the IRS could say, okay, we're going to allow you to depreciate certain things. We're going to allow you to take certain things off your taxes. If you cheat, we also can create penalties. So all the federal administrative agencies, and there are a lot, were created by the U.S. Congress. And what Congress essentially did was it gave them certain power. These agencies are very much kind of mini governments. They can investigate problems. They can make rules. So I mean, you have the agricultural agencies, the Food and Drug Administration, or the Department of Agriculture. It might say, okay, we're worried about an infection of boll weevils, so we're going to make a rule that it is a violation of agency law to move cotton between states, one of which has an infestation of boll weevils and one of which doesn't. So it could do it because it did an investigation, found out there was a boll weevil problem, made a rule about it, no moving cotton between the states, then could set up enforcement of it. Oh, we'll have inspectors. I mean, the IRS, for example, has agents that go around investigating if you. And then, believe it or not, there are separate courts. Many of these agencies have their own independent court systems built into the agencies. Now, some violations of administrative law are criminal in nature, some of them are civil in nature, but the vast bulk of new law is being made in these agencies because so many of these things in the modern world are so complex that Congress or the North Carolina General Legislature doesn't have the time or the expertise or the inclination really to regulate in these areas. The fourth major area that we could talk about, because we talked about the constitutional structure, we talked about statutory law, we talked about administrative law, now we're going to go to the last one, case law. This is a common law country. Now, not completely, and I don't want you to take that too far, but we are at least a descendant of a common law country, which means we are very interested in what old cases did. And much of American law centers around what was done in the past in a case. So let's take an example. Let's suppose that you wanted to find out, hey, if someone breaks into a tent that is pitched in a backyard, is that a burglary, or is the tent not considered a house or dwelling? Well, let's suppose that 20 years ago that same case arose. Someone broke into a tent in someone's backyard, they stole something, the courts heard all the evidence, they decided, since someone was living in the tent, it is a residence, therefore any breaking into the tent is a burglary. That established a precedent. A precedent says, here's what the general law said, burglary applies to residencies. Here is our precedent, a tent that is occupied is a residency. This is now a precedent that future courts can follow. So in the future, most courts, if they had a similar case, hey, what about tents? They'd say, okay, we have a precedent, we have this case from 20 years ago, here you go. The doctrine of this, the kind of legal, and this is going to be the beginning of the pronunciation really of some pretty bad Latin, is called stare decisis. I know it doesn't look like it's spelled that way, and I'll move my little arrow over it. Here it is, stare decisis. Stare decisis, and actually that's not a very good pronunciation because in Latin C's are typically K's in their pronunciation. Well, what's the literal translation of stare decisis? It literally translates as let the decision stand. In other words, follow precedent. Now, sometimes precedent is really important, sometimes it's not. Sometimes we will follow precedent, most of the time we will, particularly if it's from a very high court like the Supreme Court. But upon occasion we will decide that we need to break with precedent. And usually only high courts, Supreme Court of North Carolina, federal appellate courts, will really make these types of decisions. Certainly lower courts typically not. Okay, let's talk about how precedent changes a little bit because I want to use a doctrine that many of you are probably familiar with. And that doctrine is called separate but equal. In the United States, between the late 1800s and the early 1960s, we practiced racial segregation. Blacks and whites didn't mix. They obviously did, but we made it illegal. So black accommodations, and the term used then was Negro accommodations, were separate than white accommodations. And this doctrine was enshrined legally in a Supreme Court case, came up from Louisiana about a railroad case. And what happened was a black man bought a ticket to ride in, I believe, a first class compartment of a railroad. And when he got to the railroad car, they said, well, no, you're black, you can't be here, you have to go back there. And he said, no, 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 no. We had a civil war. We have the 13th, 14th, and 15th Amendments, and they say you have to treat me equally. So it went up to the Supreme Court of the United States, and the Supreme Court of the United States said, it's true we have to treat you separate. I mean, it's true we have to treat you equal, but we can treat you separately. And this is the really birth of separate but equal. And for more than 60 years, that was the law in the United States. You had, I very well remember coming to North Carolina in the 1960s, passing through at least, and coming here in the 1970s, and there were still the vestiges of this, where you could have separate drinking fountains and separate hotels and separate bathrooms. In 1954, in Brown versus the Board of Education, this is not a Southern Board of Education, this is, I believe it's Kansas City Board of Education, I know it's a northern town. The Supreme Court of the United States looked at it and they said, no, we're going to throw this precedent, we're going to change the law. Separate but equal is no longer good law. We're going to throw it out. And now you cannot have segregated facilities. And this, of course, was because even though very often, yes, things were separate, they were never equal. And, you know, there was just too many deep, deep contradictions. One of my favorite stories about this takes place in Raleigh, North Carolina, where they had the Governor Moorhead School of the Blind. Been established a long time. It was here to treat people that weren't sighted, and it was segregated. And wrap your mind around how basically crazy that is. You have to tell people that can't see color that something they can't see has such an impact that they can't be next to someone who also can't see their color. But in any event, in 1954, the precedent is changed. Separate but equal dies. Okay. What is the legal function of the law? Well, your book talks about a few things here. Your book says the law is proposed to operate as a way to protect citizens from criminal harm. I think that's at least partially true. I think that offers a glimpse into what we hope the law does. This protection extends both to individuals and to a broader society. So sometimes you have people that do things that don't have direct physical harm, but we believe are bad, so we will ban them. And very often that's because they impact public morality. And these can be things like prostitution, gambling, drugs. Now, frequently criminal laws are created because of an event. So as an example, in 1963, the President of the United States was assassinated. He was assassinated by Lee Harvey Oswald, shooting a rifle that he had purchased through the mail. And Congress passed a law that restricted such sales through the mail and banned a few others. So it's not unusual to see an event occurs and a law is passed to address it. The law also has a social function. The law reflects what the majority of people believe. In fact, you could make a very strong argument that if people don't believe something should be illegal, if they do it routinely, it's very hard to enforce that law, if not impossible. So during Prohibition from 1919 to about 1930, the United States banned alcohol. The problem was a tremendous number of people still wanted to drink. The result of which is it was largely unenforceable. People kept drinking. We have to remember that the law reflects also the political, the social, and the economic interests of the people who make the law. And very often you will see conflicts between groups played out inside the criminal law and inside regular law. So for example, not too long ago, there was a dispute in North Carolina whether we should have gay marriage. The General Legislature of North Carolina proposed a constitutional amendment to enshrine in the North Carolina Constitution that there wasn't going to be gay marriage, and it was put before the voters, and a majority of people in North Carolina voted to say there wasn't going to be gay marriage. Now, Ultimately, the Supreme Court struck that down, but it shows that there was a conflict. I mean, if you have to have a vote about something, that means we don't agree. And of course, if we go back 20 or 30 years earlier, we have conflicts for voting rights for racial minorities in the United States. And if you go back another 50 years, you've got conflicts for voting rights for women in the United States. Now, I mentioned before that sometimes you see a division of civil law versus criminal law. Civil law doesn't really concern us all that much because it really is a private thing. Typically, we have the term plaintiff. That is someone who sues the defendant. We don't call him the prosecution because he's not the state. So the plaintiff sues the defendant. He doesn't sue for guilt. He doesn't say, okay, I want to prove you're guilty civilly. What he's trying to prove is you are liable. And the remedy is not punishment. Okay, if you lose a civil suit, you don't go to prison, but damages, typically monetary damages, are awarded to the party that wins. The criminal law is when you make an act by an individual illegal, and you punish it by one of three basic mechanisms. You give him a fine, you put him in jail, or you execute him. So it's imprisonment, fines, or death. There's also a difference in what you prove, and I'm going to give you an example of O.J. Simpson. And I guess this example is getting a little dated, to tell you the truth, because O.J. Simpson was put on trial more than 20 years ago. O.J. Simpson was accused of murdering his wife, Nicole Brown Simpson, and a waiter, Ron Goldman. He was put on trial criminally. If he had been convicted of that, he would have been sentenced. I think the trial was in California. They probably have a life sentence, which would be 20 plus years. So he's put on trial. Now, he walked into that courtroom with a presumption of innocence in theory. The prosecution had to prove that he killed his wife and the waiter with evidence that established it beyond a reasonable doubt, and they failed. So at the end of the day, the judge ruled, the jury actually ruled, that he was not guilty, that he retained his presumption of innocence, and he walked out a free man. Immediately, the Goldmans, the waiter's family, and the Brown family sued him civilly, claiming he was responsible or liable for the death of his wife and the death of the waiter. There was a different standard of proof in that trial. O.J. Simpson didn't have a presumption of innocence. O.J. Simpson had to essentially argue there's not enough evidence to really show I did it. Not beyond a reasonable doubt, but by a preponderance of the evidence, and he failed. So civilly, Simpson was found liable. Civilly, the court said he killed those two people. But criminally, there was not enough evidence to prove guilt. And that's the real difference in standards of proof. Okay, another way you see crimes divided, and this is where we're going to start introducing some more language for North Carolina, is you hear them called felonies. Now, felonies are your serious crimes. These are things for which you are going to most often go to prison. And these aren't punishable by months or days in jail. These are years in prison, or very rarely to death. Typically, felonies are broken down by degree. Now, some states use up to 4 degrees. You hear it called a capital charge, or a first-degree charge, or a second-degree charge, or a third-degree charge. Now, North Carolina doesn't use those terms. For homicide, if we use the example, because homicide's a felony in North Carolina, we have first-degree murder, which is theoretically punishable by death or life without parole in North Carolina. Second-degree murder, voluntary manslaughter, involuntary manslaughter. The other two most common homicides are felony death by motor vehicle and misdemeanor death by motor vehicle. So not all states use the 1, 2, 3 or the capital. We use first and second, and then we call it voluntary and involuntary manslaughter. Misdemeanors are more minor crimes. Typically, there's not much harm in a misdemeanor. If I came up and spit at you, if I came up and slapped you, if I came up and punched you in the nose, that would be typically an assault in North Carolina. It would be a battery in other states, but we use the term assault in North Carolina. And that's usually punishable by a short period of time in a local jail as a misdemeanor. Okay, so when we say a capital offense, I've used that term once already, we're referring to a crime the maximum penalty for which is death. In North Carolina, practically speaking, the only capital offense, the only crime for which you are ever going to see someone get the death penalty is first-degree murder. Now, I believe North Carolina has a capital offense if you use weapons of mass destruction to kill someone. So if you set off a nuclear weapon, actually I'm not mad, I'm impressed if you could do that. I've got a lot of other questions on whether you did it, like how'd you get the bomb, but capital offenses, the maximum penalty is death, although it can't be the presumptive penalty. Very often you're going to see life in prison. In North Carolina, it's a minimum of 20 to 25 years. First-degree felonies are punishable by a maximum penalty of life in prison, so North Carolina has a first-degree felony option for first-degree murder. Second-degree felonies, these are punishable by a maximum of 10 years. Now that's different states typically. North Carolina's punishment can be different, and I'm going to show you a little bit later in here the North Carolina Structured Sentencing Act and make that a little clearer for you. Third-degree felonies, which we don't use in North Carolina, are punishable by 5 years in prison in some states. All right, we're going to introduce a little bit more Latin for you all. We're going to use two terms, mala in se and mala prohibita. First of all, what does mala mean? Mala means evil or bad. So mala in se, evil in itself. Acts that are inherently wrong, whether they're prohibited by law or not. If you rape someone, if you kill someone, if you kidnap someone, if you beat someone, all of those are mala in se acts. We say they're just wrong. Mala prohibita, which is an act that is prohibited, okay, people might disagree that they're good or bad. Reasonable people might disagree, but they're still illegal. So very often these are ones that we call victimless crimes, and usually they're not, no such thing as a victimless crime, but example are prostitution is illegal, bigamy is illegal, trying to have two wives, drug usage is a mala prohibita act. So there's a difference between one that really carries a moral prohibition. If someone stabs someone, someone rapes someone, someone beats someone up, you would say that's a bad thing. But if someone, your next door neighbor, has two wives, you might say, well, I don't care. Or if your next door neighbor is a prostitute, you might say, well, that's his or her business. Okay, the elements of a crime. We call the elements, the parts of the crime, the actus reus, the criminal act. In order to be a crime, you have to do something. Merely thinking about a crime, that's not enough. Very often people daydream or think about doing things. You might be driving on the Beltline, someone might cut you off, and you might think, man, I'd like to ram that car. Or someone might be acting outrageously, and you might say, God, I'd love to just slap him silly. Thinking about it's not a crime. It's got to be an act. Rarely we will punish someone if they fail to act, but usually that's called a crime of omission. Most things are commission. You did something. Omission means you didn't do it. And most of those are you have a duty to do something like feed your children, make sure someone gets emergency medical care, something like that, and you don't do it. Those can be crimes, but commission is 99%. We also sometimes have people that take substantial steps towards committing a crime, but don't complete it, and we usually will call that an attempt. It's also a crime. Just because you couldn't go all the way doesn't mean that it's not a crime. Okay, so here's an example of how in North Carolina and you would find this burglary statute in North Carolina General Statutes, Chapter 14, Section 51. Here are the different elements, the different parts you'd have to have burglary in North Carolina. You break, which literally means you have to create an opening. Either opening a door, opening a window, breaking a door, you have to make an opening. Enter. Some part of your body, or an extension thereof, has to go from the outside to the inside without consent. If you've been invited in, not a burglary. The dwelling house or sleeping apartment, so burglary only applies to your house or sleeping apartments, of another. So if I break into my own house because I lost my key, not a burglary. Well occupied. So if I break into a neighbor's house and I enter without consent and they're not home, it is not first-degree burglary. It might be felony breaking and entering in some states or North Carolina. It might be a second-degree burglary charge, but it's not first-degree. At night, if you break into someone's house during the day, it's not a first-degree burglary. And the final one, with the intent to commit any felony or larceny therein. So if you broke in to stab someone, if you broke in to beat someone up, if you broke in to blackmail someone, or extort money, or commit a rape, that's actually a burglary as well. So all of these, each of these have to be present. If any one of them is missing, it's going to be another crime. Usually, since first-degree burglary is the most serious, it'll have the most elements. And if one or more of them are missing, you're going to have a charge like second-degree burglary, or felonious breaking or entering, or misdemeanor breaking and entering, or any of those. Not only do you have to physically do something, the actus reus, but we also look at your state of mind. So we use another Latin term, mens rea or mens rea, which means the guilty or the evil mind. You have to have the mental state to commit the physical act. If you're not aware you're committing a crime, you may not actually commit one. Now, sometimes you're so careless or reckless that can substitute, but most criminal acts you do on purpose. You shot Fred. You knew you were going to shoot Fred. You purposely shot Fred. That makes it a crime. So we have different mental states such as purposefully, knowingly, negligently, or recklessly. Sometimes we don't have an awareness of the crime, but we still want to make it a crime. So we have a substitute for the mental state. And the example here is strict liability. There, we don't look at your mental state. We only ask, did you do the crime? So I'm sure you've been driving a car. You're in a 55 zone or a 45 zone. You look down at the speedometer and, oh my goodness, you're driving 70. You weren't paying attention. You didn't intend to drive 70, but you just sped up. The blue lights come on behind you. Is the defense to tell the officer, I just wasn't paying attention? No, it's not. It's not a good idea. Strict liability says, were you driving a car? Yes. What was the speed limit? 45. How fast were you going? 70. You get the ticket. You don't need to be aware. So for minor crimes, we have a lot of strict liability offenses. Some serious crimes as well. An example of a serious crime is statutory rape. I don't care whether you knew how old the person you slept with or had sex with was. If that person was underage, you are strictly liable. Period. End story. So strict liability is an alternative to mens rea. Also, you can have accomplice liability. So let's suppose you drive your friend to a liquor store. He goes in, he's got a gun, he's sticking up the liquor store, you're going to drive the getaway car, he panics, he shoots and kills the clerk. You didn't intend, but you have liability for the action, therefore you can be found guilty of the murder as well. It's called the murder felony rule. Concurrence. Concurrence, also known as causation and harm, go hand in hand with most of this. Concurrence means you have to have both the physical act, you did all the things, and the right mental state to have the crime. So let's go back to our burglary. Let's suppose that I lived on a street and all the houses were identical. And and I got drunk and came home, and I was trying to get in a house, and the door was unlocked, and I opened it, so I broke, and I entered. It was somebody else's house, so it was occupied. They were sleeping at night. I broke in, and it was at nighttime. Now, I would lack the intent to commit a felony therein, so you might have a bit of a problem, but I've done everything. Up to that point, okay, I don't have the requisite state of mind. I've done the physical acts, but I don't have the state of mind. So you can't convict me. Causation means that the act the perpetrator did must cause the harm that is suffered. Harm are the damages from the criminal act. Sometimes there's no actual physical injury, but there's an attempt. It's called an inchoate offense. Sometimes there's a conspiracy where you're planning it, but you haven't completed the crime. Okay, this was a question I threw in, one I'd like you to think about for a second. Jane is diagnosed with terminal cancer and given 3 months to live. She pleaded with her wife, Martha, to take her life. For weeks, she was adamant that she would not let Jane take her life. She was hopeful of a miracle. One day, Jane convinced Martha to take her life. Martha put poison in Jane's tea one evening. Jane went to sleep and never woke up. Martha was arrested for first-degree murder and faces the death penalty or life parole without North Carolina. Do you consider this a crime? Well, you might say, well, you know, the motivation here, Jane's motivation was she wanted to help. Doesn't matter, okay? Mercy killing in North Carolina is recognized as an intentional first-degree murder. So is there harm in the mercy killing? Less than there would be in a murder that was part of a rape or part of an arson attack or something, but we still deem it to be harm. So this is a premeditated murder. I would say it's maybe not an evil murder, but in North Carolina, you're going to be prosecuted as a first-degree murderer. Okay, let's talk about some of the defenses under criminal law. So we're going to break them up. We're going to talk about excuses and justifications. If an excuse offense exists, and we're going to talk about 4, infancy, insanity, intoxication, mistake, if it can be shown, that's it. The defendant's not responsible. A justification, if you can show it, you're going to be able to walk away as well, but you've really got to prove something that is related to the crime. The infancy, insanity, intoxication, and mistake are all states that don't necessarily relate to the crime, and this will be clear in a minute when I get to them. Okay, infancy. In North Carolina, if you are under the ages of 6, you may never be charged with a crime. So a 6-year-old, 5-year-old takes a gun, walks next door, thinks it's a cap gun, or maybe knows it's not a cap gun. Maybe he's been around his dad, and his dad shoots guns, and he shoots the neighbor. You cannot charge that child, age 6. He is, under the law, an infant. Now, between the ages of 6 and 16, and North Carolina's been changing this up a little bit, you are generally a juvenile, in which different laws may apply to you. But even as early as 13, you can be tried as an adult in some states. But until you're 6 in North Carolina, infancy is your defense. Insanity. Now, that's one of these micro lectures coming up. But insanity in North Carolina, you are unable to understand your act or distinguish between right and wrong. If you can show that, you are not guilty by reason of insanity. All states, of course, presume that you are sane. And matter of fact, 4 states don't even allow an insanity plea. It's just not an option. Insanity is illegal, not a medical term. North Carolina uses what's called the McNaughton rule. This was developed in 1843 with the presumption that everybody is sane, and you've got to show insanity by defective reason or disease of mind. Obviously, science has changed a lot. I'm going to refer you to that micro lecture if you're interested in this topic. I've got about a 5 or 10 minute micro lecture on insanity. Take a look at that. Okay. Of course, there is some debate about it because alternatives exist. And you can legitimately ask, is mental illness measured as a binary state? Are you or are you not insane? And should the legal system be doing this or the medical system? That's an interesting question. Okay, let's move on to intoxication. So when we're talking about intoxication, we could be talking about alcohol, that's the most obvious one, or we could talk about certain drugs. So voluntary intoxication is almost always not a defense. In fact, it's often an element of a crime. So if you said, yes, I did something, but I was so drunk when I did it, I didn't know what I was doing. The question would be not were you drunk, but were you drunk voluntarily or involuntarily? If I put something in your coffee, if I put some sort of pill in your tea, and that made you intoxicated, because remember, it doesn't just have to be alcohol, it could be an opiate intoxication or something like that. If you are involuntarily intoxicated, that can be a defense, but that's pretty rare. And that can be things like a head trauma or fever, sleepwalking, forcible injection or ingestion of drugs, or secret ingestion without your knowledge. Again, those are pretty rare. But intoxication voluntarily is usually not a defense, only involuntary. Okay, mistake. Two broad types of mistake that we could talk about. Mistake of law and mistake of fact. If you make a reasonable mistake of fact, that can be a defense. So here would be an example. You come into school, it's a cold winter day, you're wearing a large overcoat. You put the overcoat by the door, you go about your business. When you're getting relieved, there's an overcoat there. It's the same color as yours. It's the same size as yours. You think it's yours. You pick it up, you put it on, you walk out. You get to your car and you realize, oh my goodness, this is not mine. You made a reasonable mistake of fact. You didn't intend to steal, although you did take someone else's property. And since you took someone else's property, you've committed the physical acts, the actus reus, but you lack the mental state. Now, mistake of fact will not help you if it's not an element of the crime. So, for example, in statutory rape, it's not an element that you know the true age of the defendant. We don't say statutory rape only occurs if you know the defendant is under X, depending upon what state you're in, 16, 15, 18, wherever. So for statutory rape, mistake of fact is not a defense. What about mistake of law? Not a defense. You may not know, and even though I've been a lawyer for 30 plus years, I don't know all the laws that have ever been passed in North Carolina or federally. So if I said to you, let me make up a law maybe. If I said it's illegal to hunt ginseng on other people's land, true or false? You might say, well, I don't know. Well, in fact, it's a crime. If you went on someone's land and you dug up some ginseng, which is a root, you'd be charged with a crime. Let me make up one that's even sillier. Let's suppose I say it's a crime to go on my land and rake up pine straw. You might say, well, that can't be a crime. No. Well, I hate to break it to you, but it actually is a crime in North Carolina. It's you cannot gather pine straw without the permission of the landholder. Because you didn't know that, is that a defense? No, it's not. You can still be charged with the crime. Mistake of law is not a defense. Okay, now let's talk about some defenses that are justifications. So the other ones, we're really not going to go to trial that much on. If you can show they exist, it really destroys the ability of the prosecution to go forward. For justification defenses, you pretty much have to talk why you did what you did. I'm going to say you did everything, but it's still not a crime. So traditionally, the big one is self-defense. Now, this is a limited right. First of all, we ask the question, what level of force are you using? You can only use that force which is proportional. One of the things you cannot do, for example, is if someone's getting ready to just steal something, I'm coming up and I'm going to steal the pen out of your hand, or I'm going to come up and I'm going to steal your purse. If I am not representing a physical threat to you, your body, but I am just stealing property, you may not use deadly force. You can't shoot people just because they steal your stuff. And that's well-established law. Now, North Carolina has a stand your own ground law, and I've got a lecture on that. That's a micro lecture. I'll refer that to you. You can watch it. North Carolina adopted this in 2011, and basically we said that if you face great bodily harm or immediate death, imminent death, you don't have to retreat. Now, prior to this, if you were faced with a threat and you could walk away safely, not walk away and endanger your life, but walk away safely, you had to walk away. Now, you didn't in your own home, and that's the castle doctrine. In your own home, you can use deadly force to prevent forcible, unlawful entry. And again, I'll refer you to that micro lecture coming up. The all about rise of stand your own ground and what the impact's been. And I'm going to focus there. Really, a lot of this debate came because of that tragic shooting, Trayvon Martin being shot. But stand your own ground is a significant issue to look at. All right, necessity and entrapment, two more defenses here. Necessity means you commit a lesser crime to prevent a greater injury. And this will never apply to murder. So an example here. You're walking down the street, it's late at night, you're walking in front of a CVS pharmacy. In the CVS pharmacy, they've got a sale on bandages. So you can see through this plate glass window bandages. All of a sudden, bam, there's a car wreck. Someone's thrown out of the car and they're bleeding to death. The only way you can save them is to break into the CVS, get the bandages, come out, wrap the guy up, and save his life. If you could show that you are committing a minor crime to prevent a greater injury or a greater crime, then you have the defense of necessity. This is a very rare defense, and it will never apply to murder. You can't say I had to kill someone to save somebody else. That won't work if it's an intentional act, for example. Entrapment. Entrapment's a rare defense. Again, you show by trick or fraud or persuasion that the police convinced you to commit a crime that you weren't going to do. So you're minding your own business, the police come up to you, they pester you, and they convince you to engage in a crime that you never would have done. If you can show that's true, that's a defense. Okay, let's talk about, and we've already introduced these two terms earlier, substantive and procedural. Substantive criminal law is law that defines the rights and duties of individuals with respect to one another. So what will the state of North Carolina or the federal government punish? So most statutory law is substantive criminal law. Procedural law is really where, remember when we started these lectures, we talked about how the Constitution doesn't have a lot of criminal law directly in it. And that's true for substantive, but here is where the Constitution typically comes into play. Procedural criminal law defines the manner in which your rights and those duties of individuals are enforced. Most of this comes out of the Bill of Rights, the first 10 amendments to the Constitution. There's a smattering of other places as well. And these are basically, procedural criminal law protects your rights. Okay, what are the big procedural protections? And we're going to see these in the federal Constitution. They also exist, most of them in the North Carolina Constitution. The Fourth Amendment. The Fourth Amendment is your protection against unreasonable search and seizure. So, did the police have a warrant when they came in your house? Did they have an arrest warrant for you? Fifth Amendment. You cannot be deprived of life, liberty, or property without due process of law. Kind of self-explanatory, but basically the rules have to be followed. The Sixth Amendment. Now this has more to do with your trials. You are guaranteed a speedy trial, not defined, a public trial, trial by jury unless you waive it. You have the right of cross-examination. You have the right to an attorney. The Eighth Amendment. You can't be subject to excessive bails or fines, nor cruel and unusual punishment. And finally, the 14th Amendment, which can relate back to the 5th, gives you more due process rights. Okay, now both the 5th and the 14th, as I said,
provide due process. And due process really requires that the government not act unfairly or arbitrarily. And the judicial system really helps establish procedural due process and a little bit rarer, substantive due process. So procedural due process, the law has to be carried out in a fair and orderly way. So if I was to torture a suspect to elicit a confession, that can't be done. It is actually a violation of both procedural and substantive. Substantive is the requirement that law is used in accusing and convicting a person themselves must be fair. You don't see as many substantive violations as procedural because it's easier to show that the way in which something is done is wrong than the thing itself is wrong. Okay, getting close to the end here, folks. Victims. There is a movement to give victims more rights. In the old days, it was really up to the victim, or if the victim was deceased, the victim's family to come forward and to press criminal charges, to really get the state involved. And the king would act, if we're talking about England, or the government would act, but it really was pressed forward by the victims. Slowly but surely, this disappeared. So for example, in North Carolina, victims don't press charges. If the magistrate doesn't want to issue or judge doesn't want to issue a warrant, it ain't gonna happen. In some states, you have a little bit more leeway. Both the federal and the state governments have passed victim rights laws. And what they're trying to do is they're trying to bring the victim back into the process. And we found that's beneficial for lots of reasons. First of all, it allows something called restorative justice. It allows us to convince the victim that what they suffered offends us as a society. So we are going to inform them what's going on when the cases are going to be heard. They're going to have a right to be present so they can watch the trial. No, this isn't just being covered up. They're going to have the right to be heard. So they're going to have the right to testify. All these are really designed to help the victim because the victim has already suffered once. So we're going to attempt to help them again. Okay. It's about an hour there, so we've finished chapter 3. We'll go on to chapter 4 next, but until then, you all have a good night, or if it's a good day, have a good day.